Michael Jackson's defense team rested his case a lot faster than most people thought it would, and then they ended their rebuttal even faster, passing up an opportunity to question yet again Jackson's young accuser. The jury could actually get the case later this week. And joining us now from Austin, Texas, criminal defense attorney Courtney Anderson, and from Sacramento, California, former California prosecutor Stephen Clark. Stephen, boy, it was a dramatic and powerful ending for the prosecution. They put on this videotape of the young accuser where he was interviewed by police, and he was frightened and he was tearful, and he reluctantly and haltingly disclosed for the very first time that Michael Jackson had molested him. I mean, the courtroom was hushed. At the end, the jurors looked downward, very solemn. Big win for the prosecution there.
Absolutely. This was a great way for them to finish the case. They needed to do something in their rebuttal case. Mesereau had pretty much kicked around their case all over the courtroom throughout the trial, so this rebuttal was key. So it was a chance for the jury to get another look at this boy at a time when it was close to the molestation. He obviously was not subjected to cross-examination. But I do think in retrospect, Mesereau made the right decision by not calling additional witnesses because of the limited nature of what the evidence that did come in. The purpose that the judge said was only for demeanor. Had Mesereau done more with that, that tape could have even been highlighted.
Well, and then on cross, prosecutors could have used leading questions for a devastating narrative. And so that was another reason they didn't want to put him back on the witness stand. But Courtney, a law professor who was sitting in the courtroom and watched this videotape said, boy, this kid was incredibly sympathetic. He did not appear to be coached. There was another lawyer there who's also reporting. He said this was absolutely devastating to the defense. Isn't it true that to make matters worse for the defense is jurors have now 5 days to think about it? That's your worst nightmare as a defense attorney, isn't it?
Well, I have to concur, absolutely. And we have to remember it's not so much the opinion of the law professors and the multitude of lawyers that are commenting on this case. Right. What is the jury thinking? What is that jury thinking? We don't have a single lawyer on that jury. And how are they taking this information in? So I absolutely agree that this was a home run for the
Stephen, actor, comedian Chris Tucker may have been the most powerful witness for the defense because he spent a lot of time with the mother and the young accuser. But here's what he said about the boy. The boy was really smart and he was cunning, and his brother was definitely cunning. And here's how Tucker described the mother. It's even worse. I told Michael to watch out for the mother because I felt suspicious about her. Something mentally wasn't right. She was possessed. I mean, buzzwords like cunning and possessed might really resonate with this jury for the defense, right?
Well, I think so. And what's interesting about the Chris Tuckers and others is they are friends with Michael Jackson, and I am sure that the prosecution will point that out in their closing argument. But you remember Jay Leno, who I don't think is a friend of Michael Jackson's, came across completely different. So they're going to argue these people are close friends with Michael Jackson, and that's why you're seeing this kind of buzzword bias in favor of Michael Jackson and casting this family as a bunch of grifters. Well, but look at Jay Leno's testimony. It didn't come off that way at all.
Courtney, what about Jay Leno? Because in the opening statement, Mesereau made a big deal. Jay Leno is going to take the witness stand and tell you that the family scammed him out of money. He gets on the witness stand. He said, no, they didn't even ask for money.
Yeah, absolutely. But I think both Mr. Tucker, Chris Tucker's testimony, and Jay Leno's testimony underscore part of the defense argument. Here we have Mr. Jackson, who other celebrity friends like Mr. Tucker came to him, and Chris Tucker said, I warned him about this family. So why doesn't Michael Jackson then use any level of reasonable common sense to step away from the situation and protect himself? I mean, here's a superstar that is self-destructing, and the defense is arguing it's because he's so naive and he's been so sheltered, and because his life experience has not allowed him to be savvy enough, like Mr. Leno or Mr. Tucker, to make these decisions. If the jury believes this, though, you're going to absolutely see acquittal.
Stephen, the other promise that Mesereau made in the opening statement was you're going to hear from Michael Jackson. He's suggesting that he was, going to be taking the witness stand and testify. In the end, he didn't. Is that a promise that they may hold against the defense? And don't jurors, in the end, admonishments from the judge notwithstanding, don't they want to, they yearn to hear from the lips of the accused, I didn't do it?
Well, that's always a defense attorney trick, is you put out there as much as you can in your opening statement about what the defendant might say. And in fact, he did say some of these things in the tape. And then at the end, you stand up and say the prosecution just simply didn't prove anything. So you hope the jury takes into the jury room what you said in opening statement, that if Michael Jackson would have testified, he would have said all these things. Now, the defense has to be, the prosecution has to be very careful about commenting on that, because that is reversible error to comment on the lack of testimony. But as the jury gets in there, I think that they will focus on, wait a minute, why didn't he get up there? I mean, it's just a natural instinct to do.
They always talk. I mean, I've talked to a million jurors, and they always talk about stuff like that in the jury room. Courtney, look, you're a really good criminal defense attorney. You would never have put Michael Jackson on the witness stand. I mean, the last time he testified in a court of law in front of jurors, they banged him for $5 million in a business lawsuit. I mean, he melted under cross-examination.
Yeah, absolutely. And sometimes the defendant certainly can be one of their own best weapons. I think maybe perhaps Martha Stewart should have taken the stand in her case.
Right.
But someone like Michael Jackson, who is a very kind of unique person, and who, as a defense attorney, I'm not sure I would have been able to control, much less on cross-examination. I think absolutely they did the right thing.
Quick question for Stephen. The judge made an important ruling. He said you can't look at those naked photographs of Michael Jackson because, well, he said it's too prejudicial. The 93 accuser could identify part of his anatomy that is apparently, you know, very specific. Right decision by the judge?
I think so, and I think that the prosecution actually got lucky on this one, that didn't come in. I think that would have been perceived as somewhat mean-spirited and vindictive, which they have to avoid that appearance, because the defense is coming at him from that point of view that Tom Snen is out to get Michael Jackson. And I think the judge, seeing that that was related to the 93 incident, was the right decision. The jury, I think, would have been very taken aback by that. I think at this point the jury is convinced that he did molest Jordy Chandler and the other boy. The key is whether he molested this boy.
Whoops, I think that sound was losing Courtney on our satellite hookup. Yeah, there's another one. Belated thank you to Courtney Anderson and Stephen Clark. We appreciate it. Thank you. Coming up live on